Counsel appearing for respondents number,
All the respondents, Your
all
Lordship.
for the respondents and with the consent of the learned counsel for the petitioner list the matter after 2 weeks. Okay.
Obliged.
I seek Your Lordship's indulgence in making a mention of the Part 2 hearing list, my Lord.
Yes.
Item number 5, my Lord, even though this item is fixed for today, with the consent of the other party, my Lord, if this matter may kindly be taken up on the 9th,
9th.
yes, on the 9th, next week,
All right.
Tuesday.
On the prayer of learned counsel for the appellant and with the consent of the respondent side, list the matter again on 9th.
And my Lord, regarding item number 33
Of
the hearing list, Part 2 list, if I may be allowed to make a
Yes.
mention on behalf of the learned amicus curiae, my Lord, if this matter may also kindly be taken up on the 11th next week.
all right, 33/11.
I'm obliged.
May I seek Your Lordship's indulgence in mentioning item number 4 of Part 2, my Lord.
Item number?
4 of Part 2.
Yes.
Lord, as the conducting counsel is having personal difficulty, if the matter be taken up after 2 weeks. I've taken the consent of the
2 weeks.
Yes, my Lord.
Okay, item 4. 2 weeks. Okay, fix a date after 2 weeks.
23rd June.
Yes, my Lord. I'm obliged.
Yes. Somebody online?
No. Yes, my lord.
Daily list,
Yes.
item number 1.
My Lord, in item number 1, I'm appearing for the petitioner, my Lord. And we have filed our rejoinder to the counter affidavit filed by the respondent number 3, my Lord.
Just a moment. please.
Your lordship,
Just a moment.
your lordship may kindly,
Item number, okay, regular list. Huh? The list. Yes.
Yes, my Lord. In item number 1 of the regular list, my Lord, CRP 11 of 2024, we have filed our rejoinder to the counter affidavit filed by the private respondent number 3, my Lord.
Okay.
your lordship, we may be kindly allowed to file affidavit in opposition, my lord, in response to the rejoinder affidavit. If 2 weeks is granted, my lord, we will be very obliged, my lord.
Just a moment. So the petitioner files as against the petition, this present petition filed by the petitioner, counter affidavit has been filed.
Yes, my
Correct,
Lord.
As
Counter
against
affidavit-
that, a rejoinder has been filed.
Your rejoinder has been filed, my Lord.
So, as against that rejoinder, you want to file another counter?
My Lord, then-
Huh?
My lord, yes, against the rejoinder.
How long? Where is the provision?
The,
Against that, you will file another.
my lord. Affidavit in reply. my lord.
Against your counter, you will file another rejoinder. So, shall we go on like that? If I have understood correctly. This is civil revision of 11 of 24, isn't it?
Yes, my Lord.
So this is the York counter affidavit by respondent number 3.
There are two counter affidavit, my Lord, filed by respondents in two
This
groups.
is the counter affidavit of respondent number 3.
My lord.
Okay, as against that, you have filed a rejoinder, right?
Yes, my lord, we have filed a rejoinder against that.
Rejoinder on behalf of the petitioner. Yes, so what remains now?
My lord, the state has abstained from filing counter affidavit, so the pleadings has been complete in this matter.
Yes, pleadings are complete. Where is the scope for filing further rejoinders? One, 5, 6 and 8 also filed. So,
For 3, my lord, I think respondent number 2, 4 and 7 also adopted the,
yes.
they have made an amendment that the respondent number 3 is filing on behalf of respondent number 2, 4 and 7 also.
Just a moment. You are Mr.
T. Marangar, my lord.
Yes, for the petitioner.
Petitioner, my lord.
Yes, heard Mr. So-and-so for the petitioner. Then for who is for respondent number 1?
I am appearing for 1, 5, 6 and 8, Your Lordship.
Yes, Mr.
Lasoy Rema.
For respondents number
1, 5, 6 and 8.
1, 5, 6 and 8.
Correct.
5, 6, 8. So 2, 3, 4. Who is for 2, 3, 4
My lord,
and 7?
my lord, MS Mintan Moya,
For?
2, 3, 4, 7 and 9.
Okay, 2, 3, 4, 7 and 9. Okay, appears for 7 and 5. It appears from a perusal of the record that the counter affidavits have either been filed or adopted on behalf of all the respondents, and rejoinder affidavit has also been filed by the petitioner. This is a civil revision application and there is no scope for filing any further rejoinder affidavits. The matter is otherwise ready. List the matter for. Shall we admit it and list it for hearing?
My lord, there are, because my lord, from item 1 to 15, although the matters are not similar, but the question of law are similar. So there are some matters where the process are still awaited, and there are some matters where the pleadings are complete. So all of them have been kept in admission hearing itself, my lord. So it may be kept in admission hearing, and all may be taken up at a later stage.
If possible, my lord, on 16th of February, my lord. That is after almost 2 weeks.
Okay,
16th
so this
of
order
June,
will be only for item number 1, okay?
my lord.
Yes, my
List
lord.
the matter again for.
In individual order, my lord.
No, but in all the matters, you say it is not complete.
Yes, my lord. So individual order will go, my lord, for each.
No, in other matters, you write list the matter again on so and so. It's- For
16
admission.
June.
Okay, 16.
My lord, interim may be continued, my lord. There's an interim.
Interim orders passed earlier, if any, shall continue till the next date of listing. That is in all cases, all the items?
My lord, if only in all cases interim, but my lord, if may kindly take up one matter at a time, my lord, because there are in some cases the service is still awaited, and some cases we are still to file rejoinder, my lord.
Yes, yes, better. We take item number 2.
Item number 2.
My lord, in item number 2, I'm praying for time to file rejoinder, my lord. There's only 2 respondents. One is the private and the other is state. State has been abstained from filing counter affidavit.
All right, on
And
the
the
prayer of
private-
learned counsel for the petitioner, further time is granted to file rejoinder affidavit, list the matter again on
16.
16/6.
16/6.
Interim may be continued, my lord. There's interim this matter.
Interim, continue.
Item number 3.
My lord, in item number 3, pleadings has been completed, my lord. So it may be kept on that same day only, my lord.
Okay, so we pass the same order as item 1.
All right, my lord.
My lord, it may go as individual order for item, yes, my lord, same order, but in CRP 13, my lord. My lord, CRP 13, we have completed the pleadings, my lord, so it can be kept for admission hearing. Awaiting for orders, matter also to complete the process.
16th February, my lord, if possible, so it can be taken up together with the earlier item.
Same respondents, is it not?
No, no, my lord.
No,
it's,
different respondents.
Respondent, my lord.
Respondents
But
are
the law
different,
concept is same.
Different
my lord.
respondent, my lord.
but all are represented.
Yes, all represented.
Represented,
All
my lord.
represented in this matter, my lord.
The Hard Learned Counsel for the petitioner. Mr. Lalsorima, Learned Counsel appears for respondents number 1 to 10, and Mrs. Caroline K. Languipui, Learned Government Advocate, appears for respondent number 11. List the matter on 16/6 for admission. Interim order passed earlier shall continue till the next date.
Item number 4.
My lord, in item number 4, there are respondent number 3, 9, 10, 23, 34, 39, 42, and 43.
Item number 1, I think, please. This. Yes, item 4.
My lord, for item number 4, we are waiting appearance for respondent number 3, 9, 10, 23, 34, 39, 42, and 43. Service has been completed upon them, my lord. We are waiting for their appearance and for them to file the rejoinder of it, or the counter affidavit, my lord.
Hard Learned Counsel for the petitioner, as per office note, no counter affidavit has been filed on behalf of respondents number 3, 9, 10, 23, 34, 39, 42, and 43, and they are unrepresented. List the matter again on 16.
Interim may continue, my lord.
There is no interim, I think. Interim is there.
Interim is there, my lord. My lord.
All right, interim. Check wherever there is interim, you continue. Okay, all the
Item number 5.
My lord, in item number 5, my lord, the pleadings are complete, my lord.
Hard Learned Counsel for the petitioner. Respondents are also represented. List the matter for admission hearing on so and so.
Interim may continue, my lord.
Interim.
Item number 6.
In item number 6 also, my lord, the pleadings has been completed, my lord.
Okay, same order.
Interim also may continue this matter.
Yes.
Item number 7.
My lord, in item number 7, my lord, in respect of respondent number 43 and 44, we are waiting service. From the office note, it appears that the service has been delivered to them, my lord.
Hard Learned Counsel for the petitioner.
And we also are
Service
waiting
on respondents number 43 and 44 appear to be complete as per tracking report as reflected in office note dated 29/5/26. However, none appears for the said respondents. The other respondents are represented.
My lord, there are certain respondents but they are not yet represented, my lord. 2, 6, 8, 9. Respondent number 2, 6, 8, 9, 10, 11, 16, 19, 21, 25. As per the last order, my lord. 26, 29, 32, 34, 36, 37, 38, 39. Although the service is complete, but they are yet to be represented, my lord.
All right. See from the last order, okay, those respondent numbers along with these are not unrepresented. List again on so and so. 16. Interim continue.
My lord.
Item number 8.
My lord, in item number 8, the pleadings are complete, my lord.
2 and 5, anybody representing? Heard learned counsel for the petitioner. Re- Respondents number 2 and 5 are unrepresented. Rest
My lord,
of-
as per the last order, has been proceed without awaiting their appearance, my lord, for 2
Eh?
and 5. As per the last order, the court has proceeded without awaiting the appearance of 2 and 5, my lord.
No, we have just recorded they are unrepresented.
All right.
That's
All right, my lord.
Then the quote the last two paragraphs of 14 order dated 14/5/26. So same order with the list again on 16th.
Interim may continue, my lord.
Yes, that is there.
Item number 9.
My lord, in item number 9, we have taken fresh steps, my lord. Upon respondent 1,
Alternate
2,
counsel
4,
for the
5, 6.
petitioner pursuant to fresh steps taken by the petitioner. Service report in respect of respondents number 1, 2, 4, 5. You check the office note, okay? 29/5/26 is still awaited. List the matter for admission again on 16.
Item
Interim may
number
continue.
10.
Interim is there?
Yes, my lord. There's interim here also. My lord, in item number 10, pleading is complete, my lord.
Yes. Heard learned counsel for the petitioner and learned counsel for the respondents. List the matter again on 16. Interim.
My lord,
Earlier
interim,
to
ma'am.
continue.
Item number 11.
My lord, in item number 11, we have filed our rejoinder to the counter affidavit filed by the private respondent, my lord. State has abstained from filing the counter affidavit.
All are represented?
All are represented, my lord.
Heard learned counsel for the petitioner and learned counsel for the respondents. Rejoinder affidavit has been filed by the petitioner. List the matter again on 16.
My lord, interim may continue.
Interim.
Item number 12.
In item number 12 also, my lord, we have filed our rejoinder, my lord.
Heard learned counsel for the petitioner and learned counsel for respondents. Rejoinder affidavit has been filed by the petitioner. List the matter again for admission on 16. Interim. Continue.
Item number 13.
In 13 also, my lord, we have filed our rejoinder, my lord.
With same order.
Interim may continue, my lord.
Yes, interim.
Item number 14.
14 as well, my lord, we have filed our rejoinder to the affidavit filed by the private respondents, my lord.
Okay, same order.
My lord, here also interim may kindly be continued. my lord.
Yes.
Item number 15.
In 15 also, my lord, CRP 9 of 2025, we have filed our rejoinder to the counter affidavit as filed by the private respondents, my lord.
All right, same order.
My lord, interim also may kindly be continued.
Item number 16.
Highly obliged, my lord.
May I please your lordship? My lord, the respondent number 2, the chief engineer, BRTF, has now retired and there's a new incumbent and I have been taking steps. I have served this to the new incumbent and I'm here to file my application for impleadment. So I'm seeking 2 weeks time for filing the necessary impleadment application to implead the present incumbent of chief engineer, BRTF.
Heard learned counsel for the petitioner. It is submitted that who has retired? Respondent number 2. 2 has retired and petitioner will take steps to implead the next incumbent. accordingly list the matter again on. Any affidavits filed in the meantime,
My lord, the
which is
respondent
not
number 4,
reflected? Huh?
respondent number 4 had already filed the affidavit. The DC.
2, 3 not filed.
Now we are waiting for the
That
response.
is already, respondent number 4 is already reflected.
Yes, my lord. It may come up after 2 weeks, my lord.
Yes, given it after 2 weeks.
22nd June. Item
Deeply
number
obliged.
17.
Your Lordship, may I please? Your Lordship, may I?
Yes.
Your Lordship, may kindly bear with me to page 23, my Lord, of my humble petition. Page 23. Page 23, my Lord. Yes.
Yes.
That is the prayer portion, the prayer portion in the page 23. May I kindly read, my Lord?
Yes.
Direct the learned senior civil judge scholarship to pass appropriate orders confining any restraint or stay, if at all warranted on merits, strictly to the disputed amount of rupees 27,90,009, and to release all undisputed amounts in the petitioner bank account forthwith, my Lord. This is my humble prayer, because the undisputed amount has been restrained, my Lord. It is a matter of, my Lord, the case is about a fraudulent investment, my Lord.
Where is the impugned order?
The imputed order is in the last page, my Lord. That is in page 140 to 142. the operative portion is in page 141. After long pending, it was heard, and thereafter no proper order was passed. So it prejudiced me, my lord. I cannot move my account, which is undisputed, my lord. Page 141, my lord.
So what happened to this WPC criminal?
That was filed by me challenging the order passed by Metropolitan Magistrate, which ex parte order for transfer of my account to one of the respondent account. So in the meantime, a stay order was issued by the Honorable Court in WPC Criminal 9 of 2025, but that was challenged in division bench of this Honorable Court, and that was heard, and the Honorable Division Bench had concluded that this court has no jurisdiction to entertain the judicial order passed by different state, my lord. So it is likely to go, this Criminal 9 of 2025, my lord.
Nobody is appearing for any of the respondents?
They are appearing, my lord.
Lordship. My lord,
Yes, you are appearing
my lord,
for...
I am appearing for 1 and 2, my lord.
Huh.
My lord, in the division bench, my lord, the order which was passed in the single bench, the division bench has set aside, and since the writ petition is still pending, my lord, even it was held that the writ petition is not maintainable. And what I am not able to produce the judgment at the moment. If at all, my lordship may fix this matter along with the WP Criminal 9 on Monday, my lord, and then we'll produce the writ appeal, my lord, and then appropriate order may be passed on the same date, my lord.
All right. Let's have
On
them
Monday,
come
along with-
together.
My lord,
My
I'm
lord,
appearing for the respondent number 5.
All right. I'd heard learned counsel for the
My lord, it
petition.
may kindly come up on Tuesday, my lord.
Tuesday.
Monday, yes, I am inconvenient, my lord.
All right, let's have it on Tuesday. I'd learned counsel.
Along with the WP Criminal 9 of
Krishna, as well as learned counsel representing respondent number 1, 2 and 5. None represents respondent number 3 and 4. List the matter along with WPC criminal number
9 of 2025, my lord.
on Tuesday.
All right.
9th
Online,
of
my
June.
Thank you.
Item number 18.
Your Lordship, we have filed the affidavit. And
Yes.
Pleadings complete.
Release for admission.
Yes.
Heard learned senior counsel for petitioner and also so learned counsel for the respondents 1 to 3. Pleadings are complete. Please the matter for admission on
Your Lordship, it may be listed for hearing.
hearing.
Yes.
It is admitted already.
It's a.
Any order of admission?
It's in the order stage, Your Lordship.
Any record is required to be called for.
Court call. Court call.
Yes, it is already admitted. All right. Place the matter for hearing on.
In the meantime, Lordship, if records have not been called for,
In the meantime, call for the PCR. Okay, give a date for hearing.
July 14.
14 July.
Okay, call up the rest of the item.
14. Your Lordship, we have fixed one matter. If it can be taken up in 28th June.
Yes, give a date according to your convenience. Let's call up the next.
28th July.
Item number 19.
Yes.
Lordship, the conducting counsel for the applicant is on leg in the other court, so if the matter be passed over for the time being.
All right. Why is it for orders?
My lord, this is bail application. My lord, this is bail application. So, my lord, if it may be passed over for the time being and
All right.
taken up after lunch.
Item number 20.
Your Lordship, I am appearing on behalf of my senior Miss Mary. She has hearing at courtroom number 1. May this matter be taken after lunch? Pass over for the time being.
All right. Yes, call. We'll take them.
Item number 21 and 22.
My lord, here I am appearing as a legal aid counsel for the applicants. This IA 105 is for condoning a delay of 97 days, my lords. A notice was issued and I've taken steps upon the respondent number 1. And thus the affidavit also have been filed, my lord.
My lord, I have received an instruction to appear on behalf of respondent number 1. I'll be filing my power during the course of the day. I'll be filing my power on behalf of respondent number 1.
You're filing.
During the course of the day, I'll be filing.
You'll be filing.
And I may be granted 3 weeks' time for filing my objection against the application for condonation of delay. Respondent number 1.
Okay. Heard learned counsel for the applicant. Mr. So-and-so enters appearance for the respondent number 1. How many respondents are there?
There are 4 respondents. 2, 3, and 4 are state respondents.
Ms. So-and-so represents the respondents 2, 3, and 4. Who are the state respondents? As sought for by learned counsel, it is submitted that power will be submitted on behalf of respondent number 1 in the course of the day, and 3 weeks' time is sought to file objection. Hence, list the matter again on so and so.
My lords, if 2 weeks may be granted because there's a execution proceedings pending before the
2 weeks. Give a date after 2 weeks.
Madam.
Fixed date, okay? After 2 weeks.
19th of June.
oblige.
Deeply obliged.
In the appeal also, you write list the matter on.
If I may seek your lordship's indulgence in mentioning items 7 to 23. There are, though the same is fixed for today, there are other matters. fixed
Item
for hearing
7.
today. 7 to 23.
So all similar matters.
They are all tagged together, yes, all similar matters. So I don't
Yes.
think time will permit by today. So if this matter can be taken up after 2 weeks, my lord.
All right, 7 to
23.
23. All right. Prayer of learned counsel for the petitioner. The consent of the.
Well, I am
other side.
appearing for NHIDCL in all the matters.
Hmm?
I am appearing for NHIDCL respondents in all the matters.
No, since we are adjourning, we will not separately. Is it required to be reflected separately? Your name.
Lordship may record or otherwise Lordship may leave also.
Mr. P.J.
I am
Saikal,
present.
senior counsel, appears for response number so and so. The matter is adjourned.
Well, it will be
For
in the month
2
of
weeks.
June, my lord. July, my lord, July.
Due to paucity of time. Oh, July.
July, my lord. 17th of July, immediately after the vacation.
17 is Friday.
Then which day?
I think this matter will take 2 to 3 days for hearing, my lord. So I don't think it will be
Then 13 onwards.
on 13 onwards, my lord. 13 July onwards. Just after vacation. 20.
Okay, we'll say 14th. Is that Tuesday?
On the week commencing from the 20th, my lord. 20th July.
That will be
No. We'll fix it on a hearing day.
You requested it.
21st. Then.
But what my friend is suggesting that if it is listed on 13, according to him, it may go at least for 2 or 3 days. So it can be continued. That's what he said.
Yes, all right then.
Or Lordship may fix on 21st.
In the here, okay, this hearing list is from week to week, isn't it?
Yes, week to week, my lord.
List the matter in the part 2 list commencing from 13th of July.
One thing, my lord, perhaps my friend would be knowing whether it is admitted.
Yes, matters has been admitted. Obliged, my lord.
Item number 19.
Please, Your Lordship, in making a mention of part 2 item, Your Lordship, part 2 item number 6, today it's fixed for hearing, Your Lordship. We have a fixed matter which is due for hearing in court number 1. So if this matter can be fixed again next Monday, Your Lordship.
Next Monday.
Yes.
List commencing next Monday. Okay. The prayer of learned PP. List the matter in the hearing list commencing from next month, 8th of June. Yes.
Deeply obliged.
Item number 19.
Your Lordship, in the last court date, we were directed to obtain instructions from the superintendent whether the case of the medical case of the applicant is genuine or not. So I have contacted the jail superintendent. He have stated that his case is genuine. His pile is bleeding every now and then, and he requires a surgery. And they have informed me that they do not object if he is enlarged on bail with the permission of this honorable court during his operation. But considering the fact that he is uh, arrested in connection with the commercial quantity of NT&PS Act only during the operation, Your Lordship.
No, why is he required to be released on bail? He can be taken to a hospital
Yes.
for that purpose, and after the thing it is over, he can be brought back.
Your Lordship, apart from that medical certificate, there is a clear violation of.
On merits, that's a different thing.
Yes, my
But for this purpose, it's not as if he is required to be taken abroad or something.
Yes,
something
correct. He can be taken from the jail also.
else.
With Your Lordship, discretion, Your Lordship.
And it's a book for surgery on 16 July
16 July.
at OT Civil Hospital, Aizawl. So what is the difficulty of sending him there one day prior? That is what happens one day prior to the surgery. He is
Your
admitted.
Lordship.
Surgery is done, and thereafter, depending on the condition, he is released. After his release, he can go back. Anyway, one violation of this, let us go to that aspect
Yes.
first. You have the case diary?
Yes,
Is
Your
it
Lordship.
a charge sheeted matter?
I
Not
have
yet.
the case diary.
Yes, what is the violation you are talking about?
Lordship, violation of section 47 and 48 of the BNSS.
Okay, let us see where is the notice.
The notice is at page number 35, my lord.
Huh?
Page number 35 of my application. Here, my lord, the ground of arrest, in the ground of arrest, section 8C of Indian PS Act is only mentioned in.
No, whatever. Firstly, tell us whether a section 47 notice was issued to you or not.
My lord, section 47 notice was issued, but
Where is that?
on page number 35.
Huh?
35, grounds of arrest.
35.
Yes. Intimation of ground of arrest, my lord. My lord, your ground of arrest furnished to the petitioner only mentions section 8C of the Indian PS Act and did not disclose the full particulars of the offense, particularly section 22C of the Indian PS Act, my lord. And this is contrary to the mandatory requirement of section 47, subclause 1 of BNSS.
Yes, what is the violation?
My lord, the violation is that the full ground of arrest is not disclosed in this.
What is the
letter.
full ground of arrest?
My lord, in this ground of arrest, as I've stated earlier, it is mentioned only 8C of the Indian PS Act for the ground of arrest, and the offense, particularly section 22C of the Indian PS Act, was not
See,
disclosed.
this recovery of from inside his residence of alprazolam of 10,500 tablets, 1.060 kg, etc. All these have been, and section 8C, all these have been mentioned. What more is required?
But my lord, 22C is also the mandatory provision for the arrest.
No, that is not a ground of arrest. Ground of arrest is the recovery of the contraband. Mentioning of the section, that itself may not be, it is not a ground of arrest.
And apart from that, my lord, there is a non-compliance of section 48 also.
Yes, where is that notice?
It's at page number 37, my lord. Arrest intimation is at page number 38. My lord, if you see this arrest intimation, my lord, the materials available do not show that the petitioner's family members were furnished with the ground of arrest as required by the law, and there is also no satisfactory proof that a complete notice containing the ground of arrest is sent to the family members of the and relatives of the petitioner.
Yes, PP.
Your Lordship, there are three contentions made by, the first is the medical ground, which we not need to go again, I believe. Second is section 47. Section 47, as per the case diary which I have submitted to Your Lordship. Page number 9. This is the ground of arrest. It's in vernacular. It's in vernacular. However, the only contention that they have made is they mentioned only 8C. Now, 8C of ND and PS is possession, sale, so and so of narcotic drugs. It might not have mentioned 22C, but that does not prejudice the appellant, the applicant, in informing the reason why he was arrested, because it is written clearly that so and so alprazolam so and so 1 kg so and so was seized from his possession. And in page number 10, this is reason for arrest under section 35 BNSS. Here it's written 22C. And with regards to section 48, Your Lordship, referring to the case diary, page number 2, Your Lordship, page number 2 of the case diary, yes, it is written that section 48 notice is given on the spot to his wife. Now their contention is that, on referring to page number 11 of the case diary, there is arrest intimation under section 48 of BNSS, that there is no proof as to whether it was actually given to the accused wife or not, since she have not signed in the paper. Section 48. It was signed only by the signature of the arresting officer. Now, Your Lordship, first of all, section 48, non-compliance of section 48 is a curable defects. That is a subtle principle of law. Second is that, going through all the provisions that Vihan Kumar, Pankaj Bansal, all of them, it does not state anywhere that a signature has to be obtained. It just says that it has to be given in writing. Now it was given in writing. Even though its signature might not be there, it was given in writing.
What is the proof of the delivery?
Proof of delivery is, it can be proved before the learned trial court. Your
How
Worship.
can you say that? What is the name of the wife?
Lal Enkoli, Lal Enkoli, daughter of Kezo Liana Tamari. Her phone number also is there. Her phone number also is mentioned there. Just taking a chance that they have not obtained the signature. Her wife, his wife was there on the spot at the time of the arrest. And she was given the arrest intimation on the spot when referring to the case diary, page number 2.
What is the name? What is the name of the petitioner? Accused?
Lalsanima.
Arrest memo. Where is the arrest memo?
Arrest memo is page number 7 of the case diary.
See? No signature of any witness.
Your Lordship,
Neither any family member nor any respectable person of the locality.
name and address of witness C. Zola so and so signature is there in page number 8. Page number 8, serial number 3. And serial number 4, arrest intimation given to Lal Enkoli on the spot accused wife, relationship wife.
No, who is this Lalbiak Jwala?
Lalbiak Zwala is a local, he's, he's the local person from the place of arrest, place of occurrence.
And why is her signature not there? Neither in the 48 notice nor in the arrest memo her signature is there.
Yes, in the arrest memo, signature column is not there. In 48 also, signature column is not there.
Who prepares that? Firstly, you see the signature is not available in the section 48 notice. Secondly, in the arrest memo, you say that it was served on the spot.
Yes,
Yet her signature is not there.
her signature is
So
not
how
there.
are we to believe that it was served on the spot? Where is the proof of delivery? And secondly, and more importantly, there is not a single ground of arrest mentioned here in the 48 notice. What in the Mizo version?
Yes, nothing is there, Your
Nothing
Lordship.
is there.
Yes.
Then
It just says that now we have him in custody since 2010, 2026 for 4:35 p.m.
so what remains? Had learned counsel for the petitioner, Mr. So, learned PP. This is an application under student. So the facts is disclosed in the FIR. Paragraph 2 of the petition. Mr. So-and-so, learned counsel for the petitioner, has drawn the attention of the court to the notice issued under section 47 of the BNSS as well as the notice under section 48 BNSS issued by the police. Full stop. Para, it is pointed out that the relevant section of law, that is 22C of the NDPS Act, under which the case has been registered, has not been mentioned in the notice under section 47 BNSS, although section 8 within bracket C has been mentioned. In response, learned additional PP submits that section 8C NDPS Act is the substantive section, and therefore non-mentioning of section 22C, which is the penal section, is not of much consequence, more so since the grounds of arrest have been clearly mentioned in the said notice. Para. Further referring to section 48 of the NDPS, 48 notice, 48 BNSS notice. I think I mentioned notice earlier, no? Referring to the notice on the section 48 BNSS, learned counsel for the petitioner points out that there is neither any mention of the grounds of arrest in the said notice, nor there is any signature of the noticee stroke relative of the accused. Full stop. Learned. Additional PP submits with reference to the memorandum of arrest that it has been stated therein that the notice under stated therein that the wife of the arrested person has been informed on the spot. Full stop. However, there is from the above, it is evident that a defective notice under section 48 BNSS was issued, which was devoid of any grounds of arrest, and more so there is no proof of service of the said notice, inasmuch as the signature of the noticee is not available on the said notice. Full stop. The mere fact that it is mentioned in the arrest memo that the wife of the accused arrested person has been intimated on the spot cannot be regarded as proof of service of the notice. Full stop. The very fact that no signature of the said noticee was obtained on the arrest memo, despite claiming that she was present on the spot, also does not help the contention of the prosecution. From the above, it is evident that there has been clear violation of the provisions of section 48 BNSS in the instant case, which renders the arrest illegal, or rather which vitiates the arrest. You cut that illegal part, vitiates the arrest, as held by the Honorable Apex Court in Vihan Kumar versus State of Haryana. Full stop. Para having regard to the above, the prayer for bail is allowed. The petitioner so and so shall be released on bail of rupees 1 lakh with 2 sureties each of like amount to the satisfaction of the learned. Who is this special judge?
Special court.
NDPS. Aizol. It is further provided that the petitioner shall not leave the jurisdiction of the special court Aizol without the permission of the court, and shall not try to influence the witnesses or hamper the investigation in any manner. Full stop. Petition stands disposed of accordingly.
Highly obliged.
May please your lordship, sorry.
Item number 20.
Please your lordship, in this matter, with due respect to my learned friend, his contention is
matter?
this matter, the present matter.
The one I am dictated.
No, your lordship, the new matter.
New matter, yes.
This also pertains to section 48.
47 and 48.
47 and 48. Your Lordship, I have received the case diary and without any annexures. So if I may be given a daytime or two to obtain the case complete diary.
All right. Our learned counsel for the petitioner, learned additional PP prays for time to produce the updated CD.
Yes,
Hence, list the matter again on when Thursday.
Thursday, yes.
Deeply obliged. 4th of June.
Oh,